How is it that they get access to that type of personally identifiable information on another inmate?
I don't know, Your Honor. I'm going off of the pleadings. I would have to obtain more information from Mr. Dang on that.
Dang Sean appears from the EDCF's Zoom location. Elizabeth Fowler appears on behalf of the defendant in this case. Joshua Andrews appears as court-appointed counsel for the inmate plaintiff in this matter. This matter comes before the court at this time for its initial hearing pursuant to a writ of habeas corpus, which issued uh, uh, pursuant to a 60-1501 petition that was filed by Mr. Sean earlier. This court had earlier dismissed this case due to lack of timely filing. However, because of some doubt whether that the case should have been dismissed because he did present the initial petition for mailing within the prescribed 30-day period, the court resolved doubts in favor of Dang Sean and set this matter for hearing. Ms. Fowler has filed a verified answer in motion to dismiss. What is the current status of this case, Mr. Andrews?
Your Honor, I guess that depends on whether the court believes that there's a threshold issue of timeliness of the filing in light of Ms. Fowler's motion to dismiss, which I would interpret as asking the court to reconsider its earlier ruling that the petition was timely filed. If that is the case, I would ask for a continuance as I've not yet had the opportunity to fully explore what the deficiencies were with the original petition as to why the clerk of the district court did not accept the filing and instead rejected it to be apparently revised. If the court does not believe that that is a threshold issue and instead the court's earlier ruling that the petition was timely is still valid, then I would be asking that this matter be set for an evidentiary hearing. One of the bases for the petition is that Mr. Sean was denied the opportunity to call a witness. The hearing officer simply stated as the reason for the denial a risk of retribution, but there's no explanation as to why the hearing officer believed that there was a risk of retribution. At this point, based on that lack of explanation, I believe that it appears that the denial of the witness was arbitrary, and that the reason cited did not have an actual basis. And so I would be asking for an evidentiary hearing in which the hearing officer, who I believe is first name initial E, last name Payne, Payne, would be requesting that hearing officer be compelled to appear and testify at that hearing.
All right, Ms. Fowler, is timeliness of the filing still an issue in your view?
Your Honor, as stated in our brief, it was unclear from the record to us exactly what the deficiency was. At first glance, it appeared that there was some claim that our facility had failed to timely mail it, or it had been lost in the mail, but it appears from Mr. Sands' motion later on to have the case reinstated that it was due to his own deficiencies in his pleadings that resulted in the lack of filing. And so without further information, I think we're in a position where we do still argue that as a threshold issue, the timeliness of his filing.
All right. You're not contesting, though, that he did a timely delivery within 30 days to the facility, at least for his initial mailing?
Your Honor, I don't believe we're contesting that, no.
Okay. All right.
We are not.
My file doesn't contain any information regarding the reason for the clerk's initial filing. Mandy, do we have any docket notes of any kind in Odyssey that would indicate some sort of indication from the clerk's office why it was sent back?
5463 Calandra White.
And I think Mr. Sean had indicated that perhaps it was sent back multiple times. Is that correct?
Yeah, it was sent back 3 times.
Okay.
Thank you.
My assistant's going to check on that. She has access to the electronic record.
Affirmative, officer, can you come to your ambulance, please?
6128 now. That's right.
Thank you.
They're indicating when documents were sent back.
All right, I was going to ask Mr. Sean here, no reason for you not to be straight with me on this. Was one of the reasons it was sent back because you didn't send a docket fee or a poverty affidavit with it?
No, it's because it was I think it was on the packets that when we sent a Form 9 to get packets from the law library. It didn't come with the rest of the paperwork, like a witness, this witness form. It was an incomplete packet. I didn't know about it because I thought it was a full complete 1501 packet. I didn't know it was short couple papers. So I had to get those other papers printed out.
Okay.
Because when they give us the packet up here for the 1501 petition, that's all we get. I didn't know we were supposed to ask for these extra paper. I forgot what it was for.
All right.
But everything else, it was sent in on time. I just didn't know about those other papers.
Well, the problem is I have difficulty determining whether it was proper or not based on what other papers you're referring to. Sometimes there's in certain actions, the lack of filing of a docket fee holds up the filing. You're saying that wasn't the case here.
No, it wasn't a case.
You sent a poverty affidavit with it? I do see one that was with your eventual packet that you filled out. I don't think that the clerk's office would be sending it back for lack of proof of exhaustion of administrative remedies. That's generally would be the judge's function. So I'm just unclear, why was yours sent back?
It was missing this paperwork, and
but what was it missing?
I have to go through my paperwork I forgot what it was called. It was I think it was a witness form that I had to fill out.
What? No,
Came with
I don't
it
think
didn't come with the packet. It was like a witness. I'm trying to remember. I just can't remember what it was. It was two forms that we had to get, that I had to have my people go print it off on the website to get it sent in, to try to hurry to resend it. But it was 2 forms that I just thought the whole packet came when we asked for it up here from the legal library.
Okay. Mandy, were you able to get any information from the clerk's office or the electronic file?
No, I've been digging through this case. It looks like he had everything initially, but I'm not sure if there was something missing per clerk's.
The problem is his attempted September filing, we don't have access to that paperwork
Correct.
necessarily. We do have the subsequent materials that were eventually accepted in November, which appeared to be complete at the time. Poverty affidavit, petition was in order.
Here comes the turning point. The October 8th letter confirms the petition was rejected for an incomplete civil cover sheet and service forms. Not for lateness. That changes everything. If the filing was timely but bounced for supplements, should Sean bear the blame for procedural confusion?
Okay. Well, I'm also wondering if we don't have access to any electronic notes that the clerk's office took, perhaps there was a letter. Is that what you're saying, Mr. Sean, that you received a letter from the clerk's office detailing your deficiencies?
Yes.
Okay. Well, the clerk really should have a copy of all that. It's just not part of this file. Because what's in that very well could make a difference here. So you didn't bring that with you today when you came?
I'm kind of in handcuffs. I got.
Oh, okay. Do I? All right.
Got my file right here. I go through it.
Okay. Is there a reason why he's handcuffed for the hearing?
I'm in SEG.
Oh, okay. All right. Thank you for answering that. I knew there had to be a reason.
Is it certified? It's good. Can you find the website that is on the site?
Is there something going on there that I need to be aware of?
They're just trying to put me in belly chain so I can go through a packet that I have with me.
Oh, she's got a consent. Heavy. 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 Is that in belly chain? Belly chain. Maybe yes. I think they found the desk. They should be in control.
Boss, do we need this? Do we need this?
What?
Do we need religion for sure? Do we need them?
Wow.
Mr. Andrews, on behalf of your client, while they're doing that, kind of reaching the merits a little bit more perhaps than I should at this juncture. What difference would this witness have made? Why did he want to call this witness?
Your Honor, this would have been an exculpatory witness. My understanding from the pleadings is that the contraband was not actually found in Mr. Sean's possession. It was found in another person's possession. But the reason that they were charging Mr. Sean with the violation is because the account had been registered in his name. Mr. Sean's position is that he didn't know anything about this cell phone, that he didn't register a cell phone, and that the person who had possession of it registered it in their own name, and that person would be willing to testify to that fact. And in fact, I believe there's an affidavit that was attached to one of Mr. Sean's motions. I don't believe it was the original petition, but maybe a later motion, or it may have been in an exhibit, a different exhibit, but that affidavit is from the witness that Mr. Sean wanted to call, who was confirming that the phone was his and was in his possession. So it was an exculpatory witness that would have, we believe, resulted in a different finding by the hearing officer.
Hmm. And that's his position, despite the fact that there was an AT&T prepaid SIM card which identified Mr. Dang.
Yes, Your Honor. His position is that whoever, presumably the person possession of it, when they registered the phone, they had to put a name in there, and they weren't going to put their own name in there, as it'd be pretty obvious. It'd be a pretty obvious clue as to whose phone it is if they put their own name in there, and so they put Mr. Dang's name in there instead.
And his date of birth and his prior address?
Yes, Your Honor. I think Mr. Dang had indicated that information is pretty readily available to inmates.
And how is it that they get access to that type of personally identifiable information on another inmate?
I don't know, Your Honor. I'm going off of the pleadings. I would have to obtain more information from Mr. Dang on that.
Is that true, Ms. Fowler, that inmates have access to personally identifiable information on other inmates through a computer system or some?
I turned in the application.
Okay, just a second.
Ms.
Ms. Fowler?
No, Your Honor. Whether they are able to get information through their own channels, the residents, that's not provided information between residents or between staff and residents.
Okay, do they have access to a EDCF internet network or anything that would give them access to this information?
No, Your Honor, they do have tablets, but unless they've somehow been altered or one of the residents is using a contraband cell phone within the facility, that information wouldn't be available on the internal system that they utilize for their tablets.
Okay. It looks like that the facility is cooperating with Mr. Sean's request to be able to access his papers, which I appreciate the extra effort, gentlemen. Mandy, let my 11 o'clock lawyers know, if you can, that we're going to be running a little late, it looks like.
Okay.
Ms. Fowler, hasn't it also been the case out at the prison that the mail room has been behind substantially on getting things out of the institution?
Your Honor, I can't speak, I guess, globally to that issue. Yes, there are times when the mailroom has issues getting things out timely or getting things distributed to residents timely that come through the mail. But in this instance, I didn't see that that was an issue that was alleged by Mr. Sayin. And I'm not sure that it is an issue. Again, the record isn't clear to me exactly why it appears his pleading was rejected.
Now we're deep into the merits. The prison argues there was still some evidence linking Sean to the phone, his name, birth date, prior address tied to the SIM card, but the defense insists due process was violated first. Can a conviction stand if the hearing itself was flawed?
All right. I see the plaintiff inmate is back in his chair, and you're going through your papers?
Yeah.
Okay. Again, we're most interested in any correspondence from the district court clerk's office regarding any previous pleadings you attempted to file.
Right here, it's she said
Okay, first of all, what are you referring to?
is the back from the county clerk, what reason being?
Okay, what's the date? What's the date of the correspondence?
October 8th.
Okay, so this would have been soon after you initially submitted papers?
Yeah.
Okay. Go ahead. What does it say?
It says incomplete silver cover sheet, request for service, summons required, and copies. Yeah, those are the two forms that did come with the packet that when we request for it in here, is the request for service and summons required.
Okay, it's probably going to be ineffective, but we're going to take a shot at it. Can you hold it up to your camera? Closer. And maybe you can't get. Okay, I'm not sure I'm going to be able to read it. Let me see if I can expand. Okay. And then the only thing I need to, okay. All right. This court concludes that his petition probably should not have been sent back for those reasons. I would agree that if there needed to be some supplementing of the paperwork that needed to be submitted to the clerk's office, the petition should have been accepted. Presuming, I'm also going to presume he sent a poverty affidavit the first time around because that deficiency is not noted. Then it should have been accepted, and then perhaps then anything that needed to be requested be sent to supplement the record could be done. In fact, it's actually quite routine that the court asks for additional papers be put in the record, such as proof of exhaustion of administrative remedies, which should be attached to the petition as a matter of course. But that's not the deficiency which is identified, nor the lack of poverty affidavit or docket fee. So the court sees that any doubt should be resolved in favor of the inmate on that issue. The court is not going to consider his petition untimely. It does appear that he had delivered a petition within the 30-day period to prison officials, and that there was an initial attempt to file very soon thereafter, but that initial filing was rejected by the clerk's office. In fairness to the inmate, the court is not going to hold him accountable for an untimely filing. It does appear that his best efforts and reasonable efforts were made to file within the time, and that, again, that he did deliver his paperwork for purposes of mailing within the 30-day period to prison officials. So any request to dismiss for untimely filing is rejected. Does the file in this case, Mr. Andrews, contain the affidavit you referred to earlier? I think you said there was an affidavit by this other inmate.
Yes,
Jasper, I think his name was.
Let me find it.
Unfortunately, which is usually the case on habeas petitions, there's a lot of paperwork here that doesn't matter, that gets filed, unfortunately obscuring access to the matters that do have a consequence.
Yes, Your Honor, it was Exhibit B to the original petition for writ of habeas corpus. It is, and I stated affidavit, maybe that was a gilding the lily a little bit, but it's a letter, a signed and notarized letter from a person purporting to be Richard Jasper Jr., dated August 18, 2025.
Okay, I think I'm looking at a different Exhibit B. I'm looking at Exhibit B to the Department of Corrections record set.
Yeah, this would be.
This is Exhibit B to the petition itself?
Yes, Your Honor.
Okay. All right.
I can try to count the pages here. Looks like it would be page 12 of the petition.
I've located it. Thank you.
Yeah. 417, Bono.
Voice.
25.
In the end, the judge makes it clear. Prison disciplinary hearings don't guarantee absolute confrontation rights. Institutional safety carries weight. The real question becomes whether discretion was abused or reasonably exercised. This is due process behind bars, complicated, nuanced, and consequential. Like, comment, and subscribe for more shocking courtroom stories.
I'll just note that the affidavit or statement, it's just a notarized statement, is dated August 18, 2025, but at that point, the record had already been advanced to the Kansas Department of Corrections for their consideration. So this was well after the hearing, apparently.
I believe that the letter was obtained in preparation for the habeas corpus action to be able to show the court what the testimony would have been if the hearing officer had not refused to allow the witness to testify.
And you're familiar with the document, Ms. Fowler?
Yes, Your Honor.
Mm-hmm. Obviously, this statement would not have been presented at the hearing.
No, Your Honor. And the record of the hearing does not indicate that Mr. Sand offered an affidavit or suggested an affidavit in lieu of Mr. Jasper's testimony. And Your Honor, the other thing that I would just add at this point is that the existence of contrary evidence does not make it so the hearing officer certainly would have not still found some evidence to support this disciplinary conviction. I would argue certainly there was still some evidence to support in the record that Mr. Sand was involved and was appropriately convicted of both offenses here.
And that evidence was for purposes of our record?
That evidence was Mr. Sand's name, Dang Sand, associated with the SIM card that was in the phone, as well as his date of birth, as well as a prior address that was associated with him outside of the facility. Mm-hmm. Furthermore, I would remark that Mr. Sand's first argument to dismiss the case was not that the phone was not his, but rather that his name was incorrectly, was transposed on the disciplinary report and must be dismissed for that purpose.
Yeah, that's an easily correctable misnomer. That wouldn't result in the view of this court, any infirmity in the integrity of the proceedings below. Mr. Andrews, you now being familiar, and now that we've found it, Mr. Jasper's statement, how does this even exonerate your client? I mean, just an inmate statement that he should be found not guilty, because I'm going to take, or I've been convicted of an offense too in relation to this phone, because it seems to the court that there could be multiple people being held responsible. The one responsible for owning the phone or having it in the facility, and then someone who's in actual possession of it. How does this statement even tend to exonerate your client?
Your Honor, I don't know that the statement by itself would exonerate my client, but I would argue that that statement's not really dispositive to the issue before us. The question really is, was Mr. Sean's due process rights violated when the hearing officer refused to allow him to call a witness, and the reason, and whether the reasons for her refusal to, or his or her refusal to call the witness was supported by, I guess, was not arbitrary. So again, the hearing officer stated that the reason for the refusal was risk of retribution, but there's nothing in the record that explains why the hearing officer believed there was a risk of retribution that would justify not allowing Mr. Sean to call a witness. Again, I mean, we're speculating somewhat as to what the end result would have been had Mr. Sean's due process rights not been violated, what the full testimony would have been had his due process rights not been violated. But I don't believe that we can essentially retroactively justify a due process violation by arguing that we probably would have reached the same result anyways. Fundamentally, he was deprived of due process in this hearing. He's entitled to that due process because he did lose money. So he had a property interest since he did receive a fine. He had a due process right. He has the right to call a witness unless there's a reason not to allow him to call that witness. But if that reason is arbitrary, and has no basis in any rational conclusions, then I don't believe that just giving a reason is sufficient to warrant the refusal to let him call the witness. Otherwise, it would just be a complete farce, because any hearing officer could just write down a reason, and as long as that reason can never be verified or challenged, then it's effectively the same thing as allowing them not to be, permanently denying them the right to call witnesses. So because nothing in the record establishes why the hearing officer believed there was a risk of retribution, and there's nothing in the record that would support a finding that there was a risk of retribution, we believe that it's, in order to before we even get to the issue of whether or not there was some evidence or whether or not this witness would have exonerated Mr. Sean, I think first we have to establish whether or not the hearing officer had a reason to refuse to allow him to call the witness. Otherwise, his due process rights were violated, and I believe he'd be entitled to a new hearing as a result of that.
All right, Ms. Fowler, Mr. Andrews is suggesting that if an inmate requests another inmate to testify in his disciplinary case, that witness has to be allowed to be called. Do you agree?
Well, Your Honor, we would disagree. The regulations give broad discretion to the hearing officer to make determinations about whether witnesses may testify. Again, as I mentioned before, at times when there's concern about a particular witness, particularly another resident testifying against or on behalf of another resident, then there is testimony that's offered in the form of affidavit or notarized statement, like what we saw from Mr. Jasper. However, that was not provided at the time of the hearing. That being said, I do think that our hearing officer gave a reason. I think that Mr. Andrews is asking for very specific information as to why this resident wasn't allowed to testify on behalf of Mr. Sayin. And I would let the court know that the dynamics of a correctional facility are very different than the dynamics of a regular court and what witnesses might testify. There are security risks, safety issues related to disclosing certain information and sharing certain reasons as why it may not be safe for another resident to testify.
Mr. Andrews, any reply argument?
Yes, Your Honor. The administrative regulations provide a list of reasons why a witness, including an inmate witness, can be not allowed to testify or the request would be denied. our position is that while there is broad discretion, that discretion can still be abused if a finding is arbitrary, fanciful, or unreasonable. And in this situation, we do not have enough information to determine whether this was a completely arbitrary decision by the hearing officer who just picked a reason to justify the decision so that they could write something down on the denial report. Again, if the standard is that a hearing officer can deny the request for any reason that they may want to, whether it's justified or not, then you're really stating that there is no right to call a witness. And that's not the case. You absolutely do have the right to call a witness. There's just some specific regulations that allow that decision that request to be denied. Our position is that the hearing officer did not have a valid reason for denying that request, that there's no justification for the reason cited, that it was just something that the officer cited, but doesn't actually have any basis behind it.
All right, Ms. Fowler, anything further?
No, Your Honor.
All right. Court will address this case on its merits. The court at this time will rule that there is no absolute right to call and confront witnesses in a prison disciplinary proceeding. There are institutional concerns.
We're in Butler County Traffic Court, and John Castaneda Aguilar is facing 3 charges: failure to stay right, no valid license, and no seatbelt. But here's the twist. He waives his right to an attorney and represents himself. Bold move, risky move. Subscribe for more courtroom drama.